Good evening. Happy Wednesday. I apologize for not being on top of this as maybe you think I should. I am preparing for a 5-day civil trial that is supposed to start Monday. The That's been consuming a lot of my time, so I've had to not do as much other things, and I've been getting home a little bit later and all that other fun stuff. Attorneys prepare for trials, and you're going to ask yourself, what's a first-year family law attorney doing preparing for a civil trial? Well, I ask myself that all the time. Anyway, I saw this. I have gone through it enough to make sure that it's a good recording, and it actually has the trial in it. I have prepared a little bit. I have read through the Commonwealth of Massachusetts, their Chapter 258E. I've read through the entire Chapter 258E, and I've familiarized myself with at least a basic understanding of what a harassment prevention order requires. You can see that there's definitions of all of these terms in there. So I've done that. There are a couple things. There's Chapter 265, which deals basically mostly with sex crimes or stalking or criminal harassment. These are two crimes that could potentially get you a harassment prevention order. And then in Chapter 272, the thing that can get you which one was it? It was like drugging someone to have sex with them. Which one was it? It was Section 3. Yeah, drugging someone for sexual intercourse. So obviously 272 doesn't apply. We're going to be looking at this definition right here. And since there are no allegations of sexual assault or anything like that, it could be 43 or 43A, which are the stalking or criminal harassment. Now, these two are very similar. Stalking is you have to willfully and maliciously engage in a knowing pattern of conduct or series of acts over a period of time directed at a specific person which seriously alarms or annoys that person and would cause a reasonable person to fear substantial emotional distress. And also, you have to make a threat with the intent to place that person in imminent fear of death or bodily injury. That's stalking. Now, criminal harassment is the same thing. It's just that there's no threat involved with it. It's just the willfully and maliciously engage in a knowing pattern of conduct or series of acts over a period of time directed at a specific person, which seriously alarms that person and would cause a reasonable person to suffer substantial emotional distress. Now, notice there's a bunch of things in there that there's ands. And means you have to do the things before the and after the and. So the person's mens rea, they have to willfully and maliciously engage in a knowing pattern of conduct. So they really have to know what they're doing, and they have to intend to do this with malice. And it has to be a pattern of conduct or a series of acts over a period of time. Now, sometimes that period of time could be a very short period of time. It could be like 2 or 3 acts over the period of minutes. But I'm not entirely sure what the case law in Massachusetts is. So take that with a grain of salt. I am not licensed to practice law in the Commonwealth of Massachusetts. And it has to be directed at a specific person. It can't be just a general pattern of behavior threatening people generally. It has to be targeted at a specific person. And it has to seriously alarm that person. And it has to be of a nature that would cause a reasonable person to suffer substantial emotional distress. So there's a subjective and an objective. It has to make you scared or emotionally distressed. And it has to be the kind of thing that would make a reasonable person scared or emotionally distressed. So just be, like you might be that special snowflake that gets scared or emotionally distressed over something that a normal person would be like, well, whatever. It doesn't really bother me. So that's kind of what we're looking at. In addition, there is the Massachusetts Evidence Code, Section 1106, in civil proceedings brought under General Law Chapter 209A, Abuse Prevention, and General Law Chapter 258E, Harassment Prevention. 258E is the operative one that we're looking at. The rules of evidence shall be applied flexibly, taking into consideration the personal and emotional nature of the issues involved, whether one or both parties is self-represented, and the need for fairness to all parties. So basically, they're trying to say, we're not going to be all formal about this. This is going to be a less formal hearing. The judge is going to weigh the evidence, and you don't have to be making objections. The judge will figure out what is and isn't relevant, what is and isn't appropriate behavior for the court, etc. And the judge will be able to weed through all the evidence and figure it out. So with that understanding in mind, let's dive into to this. Please tell me I hit record. Sweet. Oh, I'm not sure I want to do this. 40 minutes of Chillie.
Joshua Abrams.
All right, good morning, everyone. Before I have the parties introduce themselves, to bring to the court's attention that there are a number of people on the Zoom who have an interest in the outcome of this proceeding. I just wanted to let all the Zoom users know first, you're obviously welcome to be here. This is a public and open space and forum, but there is no recording of the Zoom that is going to be allowed or tolerated. The court is also not going to tolerate any interruptions or interference with the proceedings in any way, shape, or form. Any violation of those orders will be grounds for contempt, and sanctions will be imposed.
I just want to make it very clear that I did not record this. This is not my video. I don't know who recorded this, whoever did it, may be in contempt of court, but I am just reporting on it. I am not recording it.
So I just expect everyone's cooperation with the court's order. And now can I have Madam Clerk swear in the parties, and then you'll identify yourself.
Mr. DeCastro.
By the way, I am drinking a lovely Crystal Geyser sparkling spring water with natural lemon flavor. So if you hear me drinking, that's what I'm drinking. I wish it was alcohol, but I got work tomorrow.
Please raise your right hand. Raise your right hand, Mr. DeCastro.
Yes, ma'am, I'm here.
Raise your right hand, please. Do you solemnly and solemnly swear that the statement you're about to give this court is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. All right, thank you all. I have before me Mr. DeCastro's two requests for harassment orders against Mr. Abrams and Ms. Peters. Mr. DeCastro, are you seeking to have these orders issued against these two individuals?
Oh, yes, please. I've got my orders issued.
So I want to just pause it because I swear to God, I thought that this had already been adjudicated like a month ago. I thought he'd already sought harassment protection orders over, I guess, over Kate Peters is not running away screaming after he battered her. I swear to God, I remember it was around Memorial Day. So I must be going crazy. I thought this was taken care of, but I'm the last guy to get the news. So
It's beyond the scale of anything reasonable. It's incredible. It's astonishing.
All right, but before you tell me
what the, hold on a second. What was the pending question?
to have these orders issued against these two individuals.
Oh, yes, please.
Mr. DeCastro, are you seeking to have these orders issued against these two individuals?
The answer to that question is yes.
Oh, yes, please. I've got my orders issued. It's beyond the scale of anything reasonable. It's incredible. It's
I don't know why he's going on.
All right, but before you tell me anything else, sir, I'm going to handle this one party at a time. I did read your affidavit for both of your requests. I want you to first explain to me why I should issue an order against Mr. Abrams based on what you put in your affidavit.
That's interesting. Let's listen to that again.
To me why I should issue an order against Mr. Abrams based on what you put in your affidavit. And then Mr. Abrams, you'll have an opportunity to respond after he tells you. Just please don't interrupt him, okay?
Thank you, Your Honor.
Go ahead, Mr. DeCastro.
Based on what you put in your affidavit. Interesting. So I'm guessing that they don't use a complaint. Do they not use a complaint? Okay. Okay, so this is the affidavit is part of the complaint. So okay, I see what it is. So your complaint has to put the complaint has to put the defendant on notice about what the lawsuit is about, about what they're being, like a criminal complaint has to put the defendant on notice of what charges specifically they're facing. A harassment restraining order complaint, or in this case in Massachusetts, a complaint for protection from harassment complaint, would have to put the defendant on notice what the actions are that the petitioner or plaintiff is alleging that they've committed that qualify as harassment. You have the right to, the due process requires notice and an opportunity to be heard. And the notice is given in the complaint in the allegations that are made in the affidavit. So she's telling him something here, and I don't know yet why she's telling him something, but she's saying that, you know, based on, why should I grant you this restraining order based on what you've alleged in your affidavit? So that's interesting.
Castro.
Well, Your Honor, on August 30th, 2022, in a video called Search Success, Delete Laws, Communications.
On a video called what? Search and Said?
Found Josh Abrams, who's 7 times a felon, who's just got out of prison from armed robbery.
So, Mr. DeCastro, I'm going to stop you right there. I have the...
So, one of the things, I forget which it is in here, is that the court already has to have come on, do your thing. Temporary orders. When considering a complaint filed under this chapter, the court shall, mandatory, order a review of the records contained within the court activity record information system, the statewide domestic violence record keeping system, yada, 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 and shall review the resulting data to determine whether the named defendant has a civil or criminal record involving violent crimes or abuse. So the judge was required to do that ahead of time. So I'm not sure exactly why it's not relevant. Josh's criminal record, the objection would be that it's more prejudicial than probative if this is going up in front of a jury. Apparently this is a bench trial. I think you can have these as jury trials, but I'm not entirely certain of what Massachusetts does. But just because someone has a criminal record doesn't mean that you could just throw it out there and try to poison the well. And, you know, oh, he's a bad person, therefore I should get a civil, or a, what they call it, harassment prevention order. You still have to prove the elements of the harassment prevention order. And the alleged harasser having a criminal record is not something, it's not one of the relevant elements that you have to prove.
Benefit of having Mr. Abrams' record here in front of me. That's not the issue before me. The issue before me is what specifically you're suggesting he may have said or done to cause you to come into court and request this harassment order. So I want you to stick to the facts as they pertain directly to you.
So in the video, he's driving around Boston.
So I don't have the benefit of having Chillie's affidavit in front of me. But I make my living listening to what judges say and trying to piece together what a judge means by what they say. And judges are oftentimes trying to tell you things when they can't just straight out tell you. And she's already saying, I want you to stick to the facts. Now, maybe this is just her standard thing. I've been in California, we call them civil harassment prevention orders, civil harassment restraining orders. And I've been in more than a few civil harassment restraining order trials. And maybe that's why she's saying this. But then she says, as they pertain directly to you. That's very specific. So I'm wondering if his affidavit was rambling and talking about how I think Zane has a harassment prevention order against Kate, I think. And maybe that's where Chillie's angling. Maybe that's where he was angling in his affidavit.
Often actively looking for me, working in conjunction with Kate Peter. They have a technology hasn't caught up with the laws yet, and that's what this case is truly about.
You shouldn't tell the judge what the case is truly about. The judge knows what the case is truly about. It's literally a complaint for protection from harassment. So the case is about harassment. Harassment is defined in Section 1, Chapter 258E, Section 1. Harassment is 3 or more acts of willful and malicious conduct aimed at a specific person, committed with the intent to cause fear, intimidation, abuse, or damage to property, and that does in fact cause fear, intimidation, abuse, or damage to property, or enact involuntary sexual relationships, or most of these are also involuntary sexual relationships or attempts to get there. And then 43 is stalking, 43A is criminal harassment. So those are really what we're working with. Or of course the chapter 272 is drugging someone for sex. So the judge knows what it's about. The judge has read the affidavit. The judge knows what the case is about. So don't try to make the case about what it's not about.
The reason why your courtroom is so full of people is because there's internet trolls drawn. When you think the word troll, you have to change the name troll to harasser or harass.
So there, you have a right to a public trial. That's a constitutional right. The public has a right to see trials. You have the right to a public trial. The public has the right to access trials. It's public information. So accusing the people who are interested in an event, a newsworthy event, i.e. a courtroom proceeding, calling them trolls just simply for being on Zoom. I mean, you're stretching it, sir. I mean, which part of the definition of this definition do you believe is met by viewing a hearing?
They call it a troll in today's era, but it's just harassing someone else or being a nuisance or causing them
So,
stress.
Mr. DeCastro, you say that Mr. Abrams and Ms. Peters were driving around Boston looking for you, and is that one of the reasons why you're asking for this order?
Oh yeah, Your Honor. They have
When did that happen?
She's really trying to get him onto the subject.
That was on August 30th, 2022. My
Okay,
assistant.
have there been any other incidents?
Excuse me, ma'am?
Have there been any other incidents since this August 30th incident of them driving around and looking for you?
He was saying something about an assistant.
Reasons why you're asking for this order.
Oh yeah, Your Honor. They have
When did that happen?
That was on August 30th, 2022. My
Okay,
assistant.
have there been any other incidents?
Excuse me, ma'am?
Have there been any other incidents since this August?
So what she's trying to get from him is who, what, when, where, why, and how. So, like on this date, at this time, this person did this action and it achieved this result. That's what she's looking for. She's looking for a recounting of the facts. And I'm not guessing that he's going to give them to her.
August 30th incident of them driving around and looking for you.
Yeah. So I was in Boston and New Hampshire from around August 28th till September 5th or so, September 7th. And Miss Peter visited my home where I was in Boston visiting with a friend. She took a picture. Now, the incoming documents that I have from my assistant will show you. I've already called the police on this one.
Assistant? He hasn't. He has an. What the What the fuck is in it? What the fuck? I don't even get it. I don't even know. I don't even, what is he? What does he think? I don't even know. So he's accusing her of having taken a picture. She took a picture. Is that threatening or harassing or stalking?
Woman over Memorial Day. The police were already involved. It already became physical interaction.
Incident cash.
Calling the police. A lot of people like to say, "Oh, I called the police. Oh, I got a police report." A police report is just what you told the police. It carries no more weight. You called the police came. Congratulations. What does that mean? It means nothing other than the fact that you called the police. Oh, they took a report. Yeah, what is their report? Their report is what you told them. It's literally hearsay. If you're offering it for the purpose of the truth of the matter asserted therein, it's hearsay. So him saying, "Oh, the police, blah, blah, blah." Well, did the police arrest somebody? That shows at least probable cause. Are there charges being filed? That shows at least probable cause. The court might take an interest in it at that point. Were they convicted? Definitely the court will take an interest at that point, depending on what they're convicted of, I should say.
So are you talking to me about Miss Peters right now?
They work in conjunction, Your Honor. So
Peters is.
sometimes the stories kind of blur. I apologize. They work in
So I'm
conjunction.
focusing on Mr. Abrams right now. I want you to limit.
So what he should have done is he should have wrote down ahead of time, at this location, this person did this, and that caused this result. And he didn't do that. So I don't know why. I think maybe he thinks he's talking to his YouTube audience at this point.
What you're telling me to what he may have said or done that caused you to come into court and request this order. And I appreciate that there may be some overlap and you might have to repeat yourself when it's time for me to hear from Ms. Peters, but I want you to address specifically and solely what you're alleging Mr. Abrams has done.
Well, Your Honor, so I know you have.
Specifically and solely what Mr. Abrams has done. So Chillie won't address any of the trolls or Kate Peters is just specifically and solely what Josh Abrams has done.
Record in front of you, but being a felon is a scary thing, and then he was acting
Being a felon is a scary thing.
on a video, driving around, accepting donations, looking for me
Driving around and accepting donations while looking for you. And that's scary, huh?
while I was in Boston. And what Kate Peters does is she marks my location, and then she sends a troll farm, a harassment farm after me.
So now we're back on Kate Peters. He really is fascinated with Kate Peters. What she does is she marks my location, and then she sends the troll farm a harassment farm after me. So he's trying to play with words. They're trolls. Trolls harassment. Harassment is trolling. But what he has to be showing is this definition of harassment. And I don't think that is what he's doing.
And what Kate Peters does is she marks my location, and then she sends a troll farm, a harassment farm after me. Where the laws have not caught up to where we are. I got a bunch of applications.
The law has caught up to where we are. The law has caught up to where we are. You are just in a position where you're trying to argue that things that don't match this definition should still qualify as harassment. And that's not something that the court can do because this is the definition the court has to work with. So you're going to have to get with the legislative body, whatever that is, in Massachusetts, and get them to write a new definition for harassment that includes what you think harassment is. And you have to also remember that you have to deal with the First Amendment and people's right to free speech, free press. And sometimes they get to say things and do things that you don't like, Chillie. And you have to deal with it. You have to put your big boy pants on and deal with it.
Days from people who went down, swore statements, and got them notarized for you to read. There's 4 different people.
I got a bunch of applications.
Where the laws have not caught up to where we are. I got a bunch of affidavits from people who went down, swore statements, and got them notarized for you to read. There's 4 different people who she's done this to previously.
So he's got a bunch of applications from people who went down or wrote down sworn statements and got them notarized for me to read. Well, my assistant is on his way.
These sworn statements that are notarized. My assistant's on his way to your court now. You can go swear different affidavits.
So you didn't file them. You didn't submit them with your complaint. So you are going to, on the day of trial, ambush Kate and Josh with new facts, new allegations? I believe that due process requires them to have notice, and you're trying to not give them notice. And what is who the fuck is this assistant? Like, what is your assistant gonna do? Your assistant isn't an attorney. How is your assistant gonna get in there? I don't even understand. Like, if the assistant files him with the clerk, I'm assuming that Massachusetts courts work like California courts, and if you file them with the clerk, it's going to take some time for it to get into the file and get to the judge. So, I mean, you're just a day late and $1 short. I assume you filed this complaint for harassment prevention orders. I assume you filed it maybe 20 days ago, 21 days ago. I don't know how long it takes to get a hearing, but I assume it's some short period of time, 10 to 21 days, 14 to 21 days, somewhere in there. Maybe 30 days tops. So, I mean, why didn't you file them with your complaint?
It's beyond incredible, Your Honor. You can't imagine what I'm going through. You can't even fathom it. They're stalking.
Well, she's not supposed to fathom what you're going through, dude. You're supposed to tell her. You're supposed to use your words. On this date, at this time, this person did this act that caused this result.
And Josh drove around saying he's looking for me.
With all due respect to you, Mr. DeCastro, you told me about two things, one of which was on or about August 30th, where you say that Mr. Abrams and Ms. Peters were driving around looking for you. And then you tell me about August 28th through August 9th, where perhaps a photograph of you was taken.
No,
so it's not clear to me what exactly you're experiencing or going through, and I'm asking you to be clear.
So, okay, on August 30th, Kate Peter posted a picture of herself at the lobby of the apartment I was staying.
She posted a picture of herself. Oh my, Chillie, that must have scared you. God bless Kate. She's not the most attractive woman in the world, but it's not scary to see her.
Staying in Boston. What that does when she posts a picture, which my sister has 2 moments on the report now, she marks where I'm at, and then once.
So by her posting a picture, it marked where you were at. It marked where you were at. Why didn't she just give me your address? Why did she have to post a picture there?
My location is marked. She has 25,000 professional harassers who will look up where I'm at, my location, anybody that owns anything around me that I'm associated with, and then they'll inundate them 74 hours.
First of all, that sounds like what her harassers are doing, not what she's doing. And I don't know what a professional harasser is. I mean, are they getting paid to do this? How do you know there's 25,000 of them? And if they're capable of looking up your location, why do they need her to go take a picture? If they're capable of finding anyone that owns anything around you that you're associated with, why do they need her to go there and take a picture? And inundating people who aren't you has nothing to do with you.
Are other people who these people will mass contact in the attempt to harass me.
So, mass contacting other people is not you. They have to do these things to you. See, like they have to do willful and malicious conduct aimed at you. Aimed at you. Irritating other people by contacting them is not harassing you.
And so they went to my place in Boston. She literally posted a picture on her communication on YouTube. I believe it was August 29th or August 30th, September 2nd. I have the actual photograph. And you've gone about the picture. I mean, we get it. She took a picture, but who cares? then was staying at a summer home out in New Hampshire in the middle of nowhere. They drove out there, put up a sign that says Kate always wins, put up balloons. I have pictures of all of the stuff.
They did that, but Kate didn't. See, you got it. You're alleging that Kate did these acts. You've alleged she took a picture, and then someone else drove out to New Hampshire and put up balloons?
In the text messages with the people whose house they went to that freaked
And they didn't even go to your house.
them out because it's in the middle of nowhere in New Hampshire. They had to drive 100 miles to get there. So it was
So they had to drive 100 miles from where to get there? Where did these harassers that showed up to the house in New Hampshire, where did they come from? You don't know. You haven't made any statements that show how you would know where these people came from.
And when was this New Hampshire incident, sir?
what's that?
When was this New Hampshire incident?
It would have been September 5th, September 6th. I have screenshots of the text messages coming from the homeowners saying, what the heck is this? Who are these people coming out? They were alarmed, and they fired my friend who works for them.
Again, that's not you. That's not you. These homeowners being alarmed is not you. Your friend getting fired is not you.
He had to fight for his job back because they were so spooked. This man is so on.
Them being spooked isn't you.
I don't think you understand what's going on. She just marks the location, and then they come after you.
See, she just marks the location. She just marks the location. She just marks the location. You're an idiot, Chillie.
Other affidavits, also notarized. You'll be able to read it yourself.
Those aren't going to be in front of her. If you're sending, I'm gonna call this in advance. I haven't seen it, but him testifying about affidavits that aren't in front of the judge is hearsay. First off. Second, I don't know if the court is going to allow those affidavits because those affidavits in themselves are hearsay. They're out of court statements that are offered to prove a fact when the person isn't there to be cross-examined. So I don't even think the affidavits are going to be, even if his assistant gets there, and even if his assistant gets these things in front of the judge before the hearing's done, which I doubt. I don't think the judge can properly consider them because they would be hearsay. See, it's like Chillie can submit an affidavit with his complaint because he's there to be cross-examined about it, for the defendants to ask him questions. The defendants can submit affidavits, I would assume. I mean, the affidavits in and of themselves wouldn't be anything meaningful, except it might inform the court as to what they intend to testify about. But then they could testify in it, and Chillie could cross-examine them. And the court is... But these affidavits, I mean, the people aren't there. If the people were there and he can call them to testify, maybe. But I'm not entirely sure if this is a full evidentiary hearing. This is probably... So in California, these things are like, unless you actually like have an attorney and you say that I'm going to call X number of witnesses and you kind of inform the court and the court can set a trial date sometime out in the future, they're normally handled on a short cause calendar, like 20 minutes kind of thing. So I'm surprised this is 40. So I don't know exactly.
I mean, it's taking me a month for
I don't know exactly because I'm not an attorney in Massachusetts and I've never done a harassment protection order in Massachusetts.
and there's how many people that she just contacted. You know, it's crazy. I have a federal tort lawsuit against both of them. So now that I have the tort lawsuit served, now I can get a subpoena for Airbnb, where they came to my Airbnb on May 22nd and marked my location. They put it in a Discord server called the Chillie Watch Discord server.
Hold on. So you don't have the evidence, but now that you have a tort lawsuit against, because it's important to state that it's a tort lawsuit. It can't just be a lawsuit. It has to be a tort lawsuit. Now you'll be able to get evidence about how Kate did something to Airbnb, but you don't have that evidence yet. You don't have that evidence yet. But you're at trial now. See, the problem is you have to get your ducks in a row before trial. Like, that's literally what I'm doing. That's what I've been doing most of this week is trial prep, is going through all the evidence that we've gathered up throughout the discovery phases, and and putting it all together into a timeline. I literally have a timeline. This date this happened, this date this happened, this date this happened, this date this happened. So I know what's going on, and I can put things into context. I have the various things that I can use and submit to the court, the various exhibits. So yeah, I mean, saying like, oh no, now I can get discovery in this other case, and I could subpoena this document, blah, blah, blah. It's too late. You're at trial, buddy.
And then they came to my house at 3 o'clock in the morning and tapped on my windows and doors.
Who is they? Who is they? They marked my location, put it in the Discord server called the Chillie Watch something server, and then they came to my house. Who's they, Chillie? Was it Kate Peters' or was it Josh Abrams, or was it someone else?
I grabbed my gun. I was terrified. I was in Ohio. And then the next
It was in Ohio. It was in Ohio. So are you alleging that Kate Peters' and or Josh Abrams went to Ohio and tapped on your windows?
day, someone walked into my house, I put a gun to his head, I didn't know who it was.
Was it Kate Peters' or was it Josh Abrams?
Let me ask you this, Mr. DeCastro. Why do you think Mr. Abrams and Ms. Peters are doing this?
Ma'am, that's what I'm trying to say. It's a thing on the internet now. It's called trolling, but it's called harassment. And what they do is they get...
It's called trolling, but it's called harassment. So, there is a specific definition of harassment for a harassment protection order. This is it. Trolling online is not this. And this is not trolling online.
I understand what harassment is, sir. I understand what trolling is. But my question is, why would they be trolling or harassing you?
That's how they make money on us. They make money by finding someone who has a big personality. It's not just me. They'll attach to any person. They've been doing this for years. I have affidavits by people who also have the same story as I do. And as a matter of fact, Kate has a criminal case coming up where she violated a harassment protection order last month. She has a criminal case coming up this week. And then...
But that doesn't have... She has a criminal case coming up. She hasn't been convicted of violating a restraining order. And so the judge can't take notice of it because it hasn't been adjudicated yet. So the judge can't take notice of it. Just because she has a case coming up doesn't mean she's guilty of it. And it's not your harassment protection order that she violated, is it, Chillie?
Another guy also had a harassment protection order in this court on Friday, and then another one in New Hampshire on Monday. I mean, the law is finally catching up to this woman. But...
So because other people have filed it means that you've been harassed? Because other people have filed it might indicate they've been harassed. But how does that mean you've been harassed? Because remember, you have to prove that you were harassed within this definition of harassment.
But this is what she does for a living. She finds someone who's really outgoing, has a big personality, and then she attaches them and harasses them professionally with 25,000 harassers. She hates people. Your Honor, if I can question her, you'll
She hates people.
see what she's doing is criminal. I can prove it right here in this courtroom today.
He wants to question her. So this probably means that he's not going to get to question her, because again, taking into consideration the personal and emotional nature, the judge will question. The judge will allow each side to speak. Will ask pertinent questions. I shouldn't say that. If it was California and they were two pro pers, that's how it would work. I guess I don't know Massachusetts law. He might get to ask them questions. I don't know. I shouldn't jump the gun. I apologize. I'm not licensed to practice in Massachusetts.
I prove what she's doing is criminal.
But it appears, because right now the judge is questioning him, I assume the judge is going to question them. And I don't think he's actually going to get to examine them.
It sounds like you're saying a lot of she's and hers. It sounds like the bulk of what you're telling me relates to Ms. Peters and not to Mr. Abrams.
They're pretty cracked, Your Honor. They're head to head. So Josh Abrams, what she did, Your Honor, and I have these thousands of texts.
They're frickin' frack, they're hip to hip. So you're trying to say that if she does something, he's responsible for it. And if he does something, she's responsible for it. It doesn't work that way. That's not how the law works. You are responsible for your actions unless you can prove conspiracy. I don't know that there's conspiracy to commit harassment. You're gonna have to prove what he's done is harassment and what she's done is harassment. And is his upper lip sweating? Are you sweating, Chillie?
He's being my friend, and the whole time he was acting like my friend, he was giving my location to Kate Peter so that she could bombard me. She showed up and physically had physical interaction.
That she could bombard me. So wait, hold on a second. Maybe I'm dumb. Maybe it's Maybelline. But I thought she marked Chillie's location, but now it's Josh Abrams marking Chillie's location. I thought she marked the location so that her trolls could come and harass you, but now it's Josh Abrams marking your location so Kate Peters can come and Kate Peters can come and harass you. If you're going to start telling lies, you should at least pick consistent lies.
Where I went to the police, I filed a police report because we physically interacted. Remember, I don't know her.
It looks like he has a third grade art project behind him, where he's cut out the faces of various people and plastered them up behind him. Doesn't that look like a third grade art project? I mean, his child must be very proud. Sorry, I was paying too much attention to all these. Let's go back a little bit.
Physically have physical interaction with me, where I went to the police, I filed a police report because we physically.
She showed up and physically has physical interaction with me, where I went to the police and I filed a police report because we physically interacted. Are you saying that she assaulted you? And if so, why don't you just say she hit me, she punched me, she pushed me, or whatever?
Interacted. Remember, I don't know her. I've never dated her. We want friends, we want coworkers. I don't know this woman. She just does this to people on the internet. And what she does, though, remember, she's just a marker. She marks your location, and then she says it wasn't me.
I thought she goes and physically interacts you. Wait. Oh, maybe I'm just tired. I'm sorry. None of this makes sense. So first it was she marks your location and then the trolls come. Then Josh Abrams marks your location and she comes and bombards you. She physically interacts with you and you don't date her or something. And now she's just the marker again. I'm not particularly convinced.
The key to your house and put dog shit on your doorstep, which I have a video, so I'm coming to show you.
Wait. And then she says it wasn't me that came into your house and put dog shit on your doorstep, which I have a video from the
They put dog poop all over the floor and broke my doorknob. My van was stolen out of my driveway 3 weeks ago. Video, so I'm coming to show you. They put dog poop all over the floor and broke my doorknob.
They put dog poop all over her door. They put dog poop all over a door and broke the doorknob. Who's they? Is it Kate Peters', Josh Abrams, or the trolls? And who stole your van, Chillie? Was it Kate Peters'? Was it Josh Abrams? Is that 3 or more acts of willful and malicious conduct with the intent to cause fear, intimidation, abuse, or damage to property? Is that 3 or more acts of it, Chillie?
My van was stolen out of my driveway 3 weeks ago.
You haven't even alleged that it was Kate Peters' or Josh Abrams who did it yet.
It's scary. I mean, whether I like it or not, I'm not afraid of Captain Peter. I'm afraid she's the marker. And then the bad people come back.
He just said he's not afraid of her. This guy's a fucking idiot.
I mean, whether I like it or not, I'm not afraid of Captain Peter. I'm afraid she's the marker. And then the bad people.
He's not afraid of her. He's not afraid of her.
Will come after him. And there's a guy named Joseph Hart who wrote me an affidavit. He explained that she's the same thing to him, and he almost got hurt badly. I have a sworn affidavit from coming in.
So, sir, you're referring to affidavits, which I don't have in front of me, so I'm not going to consider that. Now, what I am going to do right now is turn it over to Mr. Abrams to give him an opportunity to address what you told the court. Sir, in the back, please put those papers down. You're not a part of this proceeding. Sir, if you cannot comply with the court's orders to not interfere with this hearing, you'll be ejected from the courtroom. I don't want to have to do that. The parties before me are Mr. DeCastro, Mr. Abrams, and Ms. Peters, and no one else.
That might be my assistant, Your Honor, paperwork.
Well, and your assistant is not you, Mr. DeCastro.
I'm sorry, I'm just trying to.
Oh, that was the assistant who showed up with the papers. Okay, so Chillie, here's how it works. Normally, you have to turn over what you're going to use to the other side ahead of time in these things. Like you can't play hide the ball. You can't make X allegations in your complaint and then show up with Y evidence. So that's issue number one. Issue number two is your assistant isn't an attorney. He can't submit paperwork on your behalf at trial. Oh, God. Fucking legal genius over here sending an assistant to try to hand paperwork to the court during a trial. Beautiful. Beautiful. It's my assistant. That makes you important and special, doesn't it? But he can't do shit for you in court, brah.
So I'm going to turn it over to Mr. Abrams right now to give him an opportunity to respond to what he can make of what you told the court. Mr. Abrams.
Thank you, Your Honor. Good morning.
Good morning.
If I could give just a little bit of background to explain how I know this gentleman.
Please.
Thank you. I did meet him through YouTube. We had not met personally. We travel within the same YouTube sphere or community where we do the same type of social media. At that point, we became friends. I started following him, and at one point, he did come to Massachusetts to go out and film with me. There was an incident at a Memorial Day parade in Stoneham, Massachusetts, where we attended with the intent of filming the parade, some of the police officers there, and anything in the surrounding area. At one point during the parade, now, myself and Ms. Peters actually have somewhat of a contentious past. Her job in some capacity is to report or give oversight or reviews of things.
So this is Abrams, and he is doing better than Chillie by far. Chillie was a D-. I've heard worse. Abrams is so far a solid B+. It'd be better if he was more linear. He's starting to bounce a little bit. I don't know. He may have prepared. He may not have. I did watch his live stream while I was at lunch, and he said he didn't prepare. Maybe he didn't. If he didn't prepare, he's doing well for having not prepared, but he should have prepared. If he did prepare, then he's doing okay. It's good.
Things that I do, so we do know each other, but it wasn't always in a friendly manner. We rarely ever spoke. But in this incident at this parade, which is still live and available on Mr. DeCastro's channel, Delete Laws, he started walking up to several children, mostly female, between the ages of approximately 6 and 9, and was...
Mr. DeCastro, please do not interrupt the proceeding. The warning that I provided applies to you as well.
Yeah, so that's not a good plan to try to interrupt the other side with nuh-uh. You testify, they testify, and then generally speaking at the end, the plaintiff or the petitioner gets the last word. Plaintiff usually gets first and last word. Closing argument. It shouldn't be introducing any new evidence after you've rested. So you put on your evidence, the defense puts on their evidence, and then closing arguments, and in this case it'll be abbreviated, and he just gets the last word. I'm assuming, I should say. I'm not a Massachusetts attorney, but I did call the assistant not getting to turn the paperwork in. But I swear to God, I remember something about. I swear I thought there was already a harassment protection order hearing on the Memorial Day stuff. I don't know.
Thank you, Your Honor. Still on this live video, it shows him walking up to these young children, stating that the police will rape them, to not trust the police, never call the police. About this time, I started separating myself from him because I am an absolute free speech advocate, but I feel like parenting someone's children is unacceptable, but this behavior was even more so. Ms. Peters did show up to, kind of troll us, to get us on video now, and for us to have an interaction, which I had no problem with. I did not feel threatened by it. It's the internet, you know what I mean? She was not saying anything hateful or anything that put me in fear. It seems that Mr. DeCastro immediately became upset. His live stream, also my video, is on the internet now as well. It's gone somewhat viral. where at this point he sees now Ms. Peters doing the same thing that he's doing. She's following behind him and saying, I'm with him, I'm with him. On 3 separate occasions, as seen in video, he actually steps back and body checks into her. There are 3 different points where he physically shoves her, one for about 3 to 4 feet, captured very clearly in video.
Mr. Abrams, I'm going to interrupt just for 1 second.
Yes,
What
ma'am.
date was this?
This was on Memorial Day, Your Honor.
This past year?
Yes, ma'am.
Okay.
At this point, the police did see what was going on. They said on the video and in their report that, we saw what you were doing. You're trying to bump into her. You're pushing her. He, at that point, asked if he could tase her or assault her. The police told him that if he did that, could end in criminal charges. The police asked all.
So in this case, the police report might be helpful. I don't know if Josh brought the police report with him, but the police report then would be stating the things that they saw. Now, it would still be hearsay, but there might be some sort of a business record exception that would allow the court to allow it in, or I don't know. There might be some other way to get it in. It would still, I guess it would still be hearsay, but yeah, I guess it would still be hearsay. I don't know. A court might consider it though, in the relaxed and more informal rules of evidence.
All of us to leave for the sake of the children. One last time, when the police officer turned his back, again captured on video, he turned around and elbowed Ms. Peters' wrist.
He being Mr. DeCastro.
Correct, Your Honor. Causing the phone to actually fall from her hand. At this point, as you can see from his live stream and my video.
Pronouns are not your friend. We use pronouns a lot, but using actual proper nouns is much better.
He became so physically enraged going after her that I physically, now this is someone supposed to be my friend, I'm now physically holding him back from someone I've had a contemptuous relationship with, because I'm now concerned that his behavior is either going to hurt Ms. Peters or some of the children that are nearby.
Miss Peters is.
At that point, the issue, our friendship quickly went downhill. Mr. DeCastro appeared for a restraining order in which I was a witness on behalf of Ms. Peter just several days after this event.
I fucking knew it. Oh, that's a real problem. That's a real problem for you, Chillie. I knew it. And he lost. I remember. So that's all this is res judicata. Everything that happened before that last harassment prevention order hearing is decided. It's done. It's already been found to not be harassment. So you can't bring it up again. It's already been decided. Hold on a second. I thought that you had to inform the court of any, of any actions any legal actions that you're in with these other people. I'm pretty sure. I'm pretty sure. Where did I read it? I thought I read somewhere in here that you had to notify the court of any other. There you go, right there. Any other prior or pending. So Chillie should have notified the court about that prior harassment prevention order. I know I read it somewhere in here. Maybe I'm just tired, but anyway, yeah, you have to notify the court of those. So he should have notified the court not only of the prior harassment prevention order, but he should have notified the court of the federal lawsuit as well.
He's tried to get one against her.
Yes, ma'am. This is his second attempt. It was first at the Woburn District Court. It was not given to him, and much the same as in this case, a date was set up for us to be heard in front of a judge. And in front of that case, the judge again said that there was no warrant or merit. However, when we went on break from that courtroom, as Ms. Peter was present, I went outside. Mr. DeCastro first found out that I was being a witness for her at that date. So he's just now found out. We're now in recess from court. I immediately started receiving, which I've saved.
What date was that you
This
were in
was, remember the date of that? June 12th, possibly, Your Honor.
Okay.
I immediately started receiving text messages, nothing threatening, but as a witness against him, I felt that it was inappropriate.
See, she's interested in that court date. When was that? So June 12th. So nothing before June 12th she will even consider as being harassment because it's already been adjudicated.
To now be receiving text messages saying that what I was doing was wrong and how saddened he was, but there was nothing physically threatening. At this point, Your Honor, I did start doing videos on Mr. DeCastro as these videos became public interest. Oftentimes, as you can see, the videos are of me watching his live streams, reviewing things that he said, correcting certain things that he has said. And Mr. DeCastro's affirmation on his affidavit for the restraining order, he said he gave my location to Kate Peters, causing the intimidation or danger. A lot of what Mr. DeCastro says relates to trolls and people that I have 90,000 viewers, 23 million views. I certainly cannot make people do anything. It's very clear in my videos. I always say that in no way would I wish for people to contact him. In no way am I asking for people to contact him. This is the internet. People leave comments on my things that I don't like. People leave comments on his things that I don't like. But it should be kept in mind that on the date that he's saying that, I went to follow him, what Mr. DeCastro failed to remit to the court is that he was on a live stream interviewing public.
Failed to remit to the court? Failed to inform the court?
Interviewing in public at a public place in Boston. He also announced that he had service with me. I believe the gentleman standing here today, I'm not aware of his name, but that is one of his friends or his colleagues that is now trying to stand up and I believe maybe serve us. But we were served a lawsuit or attempted lawsuit from this gentleman, so I went to get service. That's what this gentleman apparently is doing his service for him. You can see this gentleman in the video. So I absolutely
know that you were going to be served.
He made public statements, Your Honor, letting me know that there was a lawsuit that he came to
on the live stream.
Yes,
on that.
yes, Your Honor. On several live streams that he came to Boston to serve both myself and Miss Peter. That he was contacting a constable, that he was going to serve me, and I live with my elderly mother. And to avoid constables, and I work all day, so to avoid constables or people she doesn't know showing up at the house, he said, I'm going to serve Mr. Abrams as soon as I can and when I feel like it. So I felt that if he was with the person who's now available trying to serve me now when he's first seen me, then I would go and get the lawsuit in hand.
Well, it's silly to go see Chillie because Chillie can't serve his lawsuit. It has to be someone else, someone who's not a party to the lawsuit, who serves it. So, I mean, you're taking a lot of gamble that there's going to be someone there with Chillie who would be willing to serve the lawsuit and sign the proof of service.
He wound up ending his stream. I did not seek to go find him after that. I did conduct several more videos, but nothing certainly with credible threats or fighting words. He says that I announced that I was working with several Discord.
Credible threats or fighting words. Fighting words is a First Amendment concept. Fighting words in the First Amendment arena are things that are likely to cause an immediate breach of the peace. So I don't know. I don't know how he's using that. Because this isn't a First Amendment case, so I don't know. I think he means true threats, but good enough. I think the judge understands what he's saying.
But nothing certainly with credible threats or fighting words. He says that I announced that I was working with several Discord accounts as he traveled the city to find Jose. I believe this is the incident that he's referring to, Your Honor. I was on a live stream. I did not have the capacity to operate in Discord, and the Discord that he's referring to has over 2,000 people in it, most of whom I only know by a moniker or a tag name. I don't know these people. I don't ask them to go to Mr. DeCastro's house. I would ask that my record has no relevance, although I recognize my record. In this case, it seems to be confusing, as today I've brought as evidence. I was on a live stream just 2 days ago, and this is a gentleman that's saying he's in fear of his life to the point that I must need to be physically restrained by a court order. He's not verbalized anything that would put him in fear that I have done directly, either that or indirectly, or provided proof. He has, however, said in a live stream recently, for someone that is quite scared of me, he took the time to, I went onto a live stream, Your Honor, when he was there, and he dropped off, and then I continued a conversation with the channel owner for about 20 minutes, and we were talking about a case that they were covering or reviewing. At that point, Your Honor, he found it necessary, being scared for his life, intimidated by me, to come up on live stream. I have a video, about 30 seconds of that today, where he came on a live stream. He called me a rapist. He called me a fat piece of shit, which is his freedom of speech to do so. And then he made, on 2 separate occasions during this live stream, 2 separate fist gestures, and he told me that he better hope that,
So, if there's any foul language, I ask you to abbreviate. Don't say the full word.
Yes, ma'am. My apologies. He said, you better hope when I find you there's no cameras, because, you better hope there's somebody to save you.
Yeah, Chillie has diarrhea of the mouth, and his statements on live streams about that kind of stuff they're not going to play well in court. I mean, if you are going to say, like, for example, if a rapist shows up at my door, I'm going to be in fear for my life. If a rapist with a penchant for firearms shows up at my door, knowing that there's bad blood between us, I'm going to be in fear for my life. I don't want him to show up at my door. I'm not inviting him to show up at my door. I will be in fear for my life. I've never backed down from that position. I will never back down from that position. And if a rapist with a penchant for firearms shows up at my door, I will act accordingly. I will act to defend myself and to make sure that there is no longer any threat to me or my wife. If I was then to go and say, and I would never do this, that I was not in fear of him, that I would whip his ass if I saw him at a grocery store or whatever, then that would reduce the credibility of what I'm saying when I say, if a rapist with a penchant for firearms shows up at my door knowing there's bad blood between us, I will be in fear for my life. That's all I'm saying. If you're going to say something, be consistent about it. You can't plead something to the court. That old saying, anything you say can and will be used against you. Well, one exception for hearsay is an out-of-court statement by a party opponent. So Abrams can bring in anything that DeCastro has ever said as evidence against DeCastro. Statements by a party opponent, exception to the hearsay rule.
And I have that today. I brought it with me, made a fist gesture. Later on during the live stream, he told me I was going to get it. Again, Mr. DeCastro made a fist gesture on about approximately 4 other live streams. He said publicly how he could, he didn't say he was going to, Your Honor. He said he could beat the SH out of me. So these are all documented instances of Mr. DeCastro actually making violent threats against me. More so, Your Honor, I believe that this has nothing to do with any legal proceedings or Mr. DeCastro feeling in harm, in jeopardy, in any way for myself or Ms. Peters. I did bring video today as well, which I'm obliged to provide to the court, of Mr. DeCastro saying, I don't care if this goes anywhere. I'm just going to keep going after them legally. I'm going after them over and over again, and I'm going to take every dime they have until they can't afford a lawyer, until I destroy them. He quotes, obliterate them.
Yeah, so social media, I've had to defend more than one client in family law and civil law where social media statements were used against them. They get mad, they say something stupid on social media. You know that their enemy takes a screenshot of it, and next thing you know, it's being used against them. Point in fact, in the case that I have that theoretically is going to trial on Monday, there's social media posts in there and text messages and all sorts of fun stuff. I mean, what's that guy? Robert Barnes? I mean, one thing that he says that I can always agree with is never in writing, always in cash. And, if you don't want it to be used against you, never in writing, always in cash.
I believe that this is a vexatious attempt, more so proving Ms. Peters' interaction with him, where this is the first time I'm in court, but we went to a local court out of my jurisdiction. A judge denied it. We went in front of another judge, Your Honor. A judge denied that as well. We're here today, Your Honor. He cites that Ms. Peters has several different court dates coming up. It's actually from the same thing. They applied, this gentleman, I believe, if that's the correct person, filed for, again, a restraining order against her. It was denied out of New Hampshire. So when it was denied out of Hampshire, that's the hearing date, much like today that he has coming up. So it's not a separate date. He then came to Massachusetts to do it again. It appears, Your Honor, that this is an attempt to either substantiate.
That's kind of messed up, seeking restraining orders in multiple different states. Restraining orders, there is a federal statute that says full faith and credit, that each state will give full faith and credit to the domestic violence prevention orders and civil harassment prevention orders of the other states. And you can see, there you go. So Massachusetts will recognize protection orders issued in other districts, and they'll enforce them. So I don't know why you would need to get a harassment prevention order in New Hampshire and in Massachusetts. One is more than sufficient.
His lawsuit, but in no way, shape, or form have I, or do I believe Mr. DeCastro has proved today that I have uttered any true threats.
And I'm also wondering how New Hampshire would get jurisdiction over Kate Peters'
fighting words that I have
Just to go through
personally.
his affidavit on May 30th of this year, you're suggesting, he's saying you gave his location to Kate Peters, you're saying he was live streaming.
Yes, ma'am. The video is still up, Your Honor. The video, and I believe the last time I checked, it had 11 point something thousand views. Mr. DeCastro, 95% of his videos are actually live stream. And I believe the video on this date, he was actually questioning people about if they were aware of their constitutional rights. He was live for about an hour and a half.
And just credit to my point, because he was live streamed, his location was known and knowable.
Yes, ma'am. Especially where he was live streaming, because he was showing where he was at. He was talking about the significance of the building he was standing in front of. And secondly, I did not send anything in Discord because as he was live, Your Honor, I was live as well. And I can't during a live stream then leave the live stream and go through Discord. I think Mr. DeCastro mistakes and confuses whether it's his knowledge or lack thereof concerning things that if someone does something or they say, oh, you're a jerk because, Josh or Accountability for All said this or said that. That is not me. That is, my company, what I do, I portray a character online. I cover civil rights issues on my backup channel. I cover more public interest events. Because of this case, Your Honor, because this is public interest, I've covered this quite a bit more.
Mr. Abrams, you denied on August 3rd. You didn't announce, well, if you did.
Abrams is getting lost. He's talking too fast, and he's rambling. He's trying to hit various points, but he doesn't get finished with one point before he's trying to switch to a new point. So slow down, take your time, make sure that you finish your sentences, finish your thoughts. That's why it is good to at least have an outline prepared of what points you need to hit. Maybe don't write everything out, but just make sure you got the points that you need to cover.
You did announce that you were working with this court of counsel. It wasn't with the intent to have anyone else go and find him.
No, Your Honor. I didn't announce that I was working with.
She is asking about whether or not he is engaged in willful and malicious conduct aimed at a specific person with the intent to cause. She's saying you weren't doing this to have someone else go harass him, and he said no.
Discord. I did personally say, Your Honor, in complete and total honesty, that I was going to try and find, because this gentleman here was with him and is his assistant, his server for legal documents. So I did try and make an appearance to go there so I could get served. He ended an hour before I was able to get there.
And again, on August 3rd, that was another live stream where during that live stream.
I think he's actually referring to the same one, Your Honor. There was only one live stream and I still have it that I ever went in search of him.
Was there never an August 30th incident as far as you're concerned?
Unless.
Uh-oh, it's not 3 or more acts.
No, I mean, I don't think so. I mean, I think he's referring to the same incident. I could be wrong. Maybe it was mentioned in a panel or like a talk show venue where I was reciting the incident that happened.
All right.
But there was not a second time where I attempted to find him. And my actions were warranted, Your Honor, because my mother, she's 76, she is elderly, she's a retired government employee.
No, I understand. I understand why you may have traveled to wherever he was to try to get the service that he was suggesting he wanted to serve upon you. On September 2nd, he says you physically went searching for him, even asking for funds. What do you say to that suggestion?
Your Honor, I believe, again, that when we're talking about the dates where I was going to find him, I believe this stems from the same live stream that I did when I was out with another gentleman that is here in court today, and we were taking video in probably about 30 minutes from Boston of a car accident. I believe that's the issue that he's talking about. I never went to give his location to Ms. Peters, and I did ask for funds. However, that was because, Your Honor, YouTube does not pay till the 22nd. I have to appear now in court for what I believe, for all intents and purposes, is vexatious litigation. So I did explain and recount the best of my ability and my honesty what happened, my history with Mr. DeCastro, where we are at now legally with both pending civil matters as in the restraining order case and the federal lawsuit. And I have been asking that if anyone would like to contribute funds to that matter, it is greatly appreciated. We were not able to reach that goal, obviously, as I'm representing myself here today.
All right, I'm going to stop you, Mr. Abrams and Ms. Peters. I'm going to have you come up now and address the court. Mr. DeCastro, you have an opportunity to address. No, you'll have an opportunity to address everything that was said after Ms. Peters is done. The reason
I think he wants to cross-examine Josh. I don't think he gets to.
doing it this way, sir, is because your presentation, you lump them both in together, so it makes sense for me to hear from the both of them, and then you can address at the end. So I'm going to ask you to mute yourself so I can hear from Ms. Peters. Ms. Peters.
Good morning, Your Honor. We can just stick to the affidavit here, otherwise it can get extremely convoluted. I apologize for the circus. This is, for all intents and purposes, a spectacle that is, going on in front of thousands of people. I do run a YouTube channel. Mr. DeCastro, in my opinion, has been most vehemently going after me because I am female. I am more successful than he is. He seems to take exception to that. I've been a very harsh critic of his. My speech is protected. It contains no true threats and no fighting words whatsoever. Mr. DeCastro, on the other hand, since the 7th, when he asked for this order, has issued a number of veiled threats at me, telling me that I'm going to have people show up at this courthouse. He actually has someone in the courthouse right now who has filed for a restraining order in New Hampshire against me that it was denied. He actually has an active harassment order against me right now, so I have to be here. This gentleman doesn't.
That's Zane in the courtroom? Oh boy. Oh, ballsy move, Mr. Castro. Ballsy move.
I find it preposterous that these men are purporting to be afraid of me, but then going out of their way to be at the same venue that I am. This is just an ongoing campaign to chill my
You're
free
saying
speech.
this other person has a harassment order against
Active
you?
right now.
Not Mr. DeCastro?
No, Zane came in the courthouse. He came here of his own volition, knowing that I was going to be here, right?
It's not about Zane. Move on, honey. Move on.
This is sir, it's not your time to speak. Mute yourself, Mr. DeCastro. This is your last warning. This gentleman in the back of the court with
In the
sunglasses?
glasses right there. This is the second time that I've encountered this gentleman. The first time was in West Roxbury District Court when I was on a matter that did not concern Mr. DeCastro or Mr. Zane. They accosted me in the courthouse 4 times. They had to be removed by court officers 4 times. They then waited for me outside of the courthouse.
Okay. Take your time.
So
Let's
you're
get back to the
outside of the
affidavit. Let's
courthouse.
get back to Mr. DeCastro's affidavit.
Okay, I'm sorry.
That's okay.
I've never stalked him physically. He can claim that I have for the court's consideration, although I would appreciate it. I understand that usually evidence would be shared with the plaintiff. This is my location history for the last 4 months. I don't want him to know where I go.
I understand.
But I have not left the state. I don't.
Normally, but again, we're on the relaxed rules of evidence.
Leave the South Coast. I have 2 children. I'm employed full-time as a property manager. This YouTube is my second venture really. So I've never physically stalked him. I've never showed up anywhere where he was going to be. I've never caused any physical altercation.
Wait. Oh, I think the judge is thinking what I'm thinking.
Memorial Day parade.
Oh, I did at that point. It was YouTube content. He was yelling at children. He was scaring children. I went up. I was a disruptor, and it's constitutionally protected behavior. He took great exception to it, again, because I believe I'm female, and he doesn't like being stood up to by a female. And he proceeded to physically assault me numerous times. He threatened me. He threatened me in the presence not only of Mr. Abrams and hundreds of onlookers, but police officers as well.
And portions of this assault were caught on video? Were captured on video? Were portions of this assault
Yes, it was captured on video. I declined to
So
file
he
charges.
says that you physically caused a physical interaction.
In the same way that Mr. DeCastro recently wished bone cancer on children and then apologized and said that I caused him to say that. It's a page out of the abuser's handbook. He's blaming me for his behavior. At no point did I physically strike or physically approach Mr. DeCastro in a way that would invite being assaulted. He's the only one.
So, August 2nd, he says you mass-tracked, I'm not quite sure what it says, and I think he says you got him canceled. What do you say to that?
I got him canceled. He's here.
I think the mass tracking that got him canceled was the Airbnb. I think that's what he's talking about.
I don't even know what that means. No, I mass-tracked. He live streams his location. Mr. DeCastro, clearly, as we can see in his deportment before the court, he is a divisive and kind of abrasive individual. He's broadcasting himself to potentially millions of people. I cannot control that they don't like him. So he is getting trolled online. He always gives the reaction that people are trying to elicit. He constantly sort of behaves in a way that people find to be vile and objectionable. People online react to that. I have no control over that. He can't point to one instance where I've ever ordered anyone to do that. That's preposterous. I cover him because I consider it to be public interest. It is my YouTube channel as a source of income, which he takes great ire for, but at no point am I, personally making contact with him or threatening him or putting him in any fear. I mean, again, he's got his associates burying me with paperwork, asking the courts to civilly restrain me and then show up at the venue that I'm at.
August 6th, he says you got him kicked out of his Airbnb.
No, that's, again, preposterous. I would like to see how I did that.
And then...
No, you're not, so I don't know why people do this. I would like to see how I did that. Well, no, you just say no. No, I didn't do that. I've never done that. I wouldn't even know how to do it. I would like to see how I did that. No, the court isn't there to prove things to you. The court is there to get you to answer the questions.
And sort of reverse order, he says June 12th of this year, you stalked him physically.
To his Airbnb, again, I have my location information. No, I'm not stalking him physically. I mean, as far as to paraphrase the law, I'm certainly not an attorney nor judge, but I mean, stalking has an element of physical danger written in there. At no point did he point to any time that I've, even put him under the impression that he's physically in danger of me.
Stalking has a requirement for a physical threat, or a threat of a true threat. Load. Makes a threat with the intent to place the person in imminent fear of death.
If anything, I would say the contrary is true. He's made numerous threats against both myself and Mr. Abrams and anyone who dares to criticize him online.
And do you agree with Mr. Abrams that the two of you sort of were contentious before?
Extremely. I put out this man's entire criminal record at some points, and been very, very harshly critical of his treatment of police officers. We have different, but I mean, apparently we can both align in this goal, which is that, this man is abusing the court systems and it needs to stop. And I would hope that it would stop today. He did not come in here asking the courts to give him protection. What he is expecting the courts to do and has been very vocal about is to exercise prior restraint on my free speech.
Is there anything else you want me to know, ma'am?
No, ma'am. Thank you.
All right, thank you. Mr. DeCastro, now's your opportunity to address everything that you've heard in the form of a closing argument, okay?
In the form of a closing argument, yeah. So he's not here to adduce new evidence. He is there to respond to what they've said and to argue as to why the court should find in his favor.
Your Honor, if we don't introduce my witness and the evidence, it's a travesty of justice. You're listening to people stand up there and give you a story with no evidence.
Mr. DeCastro, I need you to slow.
Their testimony is evidence. You can call it a story, but their testimony is evidence. Your affidavit has, in quotes, stories, end quotes, in it. It's evidence. Their statements are evidence as much or more so than your affidavits are evidence. And I'm surprised he has witnesses there. Interesting. I wonder if it's Zane is his witness.
Slow down your speech. I need you to slow down your speech because I'm having a difficult time understanding what you're saying. It's very muffled in this courtroom, so slow down.
Okay. So what I'd like to do, Your Honor, is I'd like to bring in my evidence, because what you're listening to right now is a couple of people who they're not the good people in this. Now, what I did.
I would like to bring in my evidence because they're wrong. I'm going to nope my way out of this one.
I became a national figure when I created a timeline that showed.
He's a national figure. Well, by his own lips, I guess we can say he's a public figure now because he's a national figure. Oh, Lord. I mean, just way to help out Kate and Josh on the defamation claims. Let's listen to that again.
Now, what I did, I became a national figure when I created a timeline that shows the history of lynchings in our country in comparison to the history of prison charges.
I don't think so, buddy. But okay, I think you became a national figure when you made an ass out of yourself.
I became a national figure. Now people started to recognize me. These people, what they've done now is they're stalking me through private news board accounts with anonymous people. Now you're listening.
Mr. Castro, I have a hard time understanding how you're being stalked if you are publicly displaying your location by way of your live stream. Are you not live streaming?
Ma'am, if you don't let me talk, then you won't hear me.
I have a question.
Well, that's ballsy. That's ballsy. It's her courtroom, and she gets to ask you questions, and you have to answer her questions. I mean, if you want her to rule your way, you do. Or you can talk down to her. You know, it's funny. I wonder why Chillie's talking down to a black woman. I wonder why he's talking down to a black woman.
Question though. I have a question for you. Did you answer my question? Are you live streaming your location?
No, ma'am, listen. You don't understand. What is happening is criminal. I'd like to introduce evidence.
What's happening is criminal. Interesting. Why aren't charges being filed then?
At this point, you're just hearing stories. I spent the last 2 weeks.
With all due respect, Mr. DeCastro, stories or testimony is evidence. So I'm taking your testimony, I'm taking the testimony of Ms. Ava.
I mean, you're not letting me finish at all. One is a 7-time felon, and the other one is on mandatory statement.
Yeah, so again, not the fact that he is a felon, including 7 times, doesn't mean that he is harassing you, as defined in Chapter 258E, Section 1. And I've never heard of anybody being on mandatory state medications who's out and free. But assuming arguendo that it's true, that Kate is on mandatory state medications, again, that doesn't mean that she's harassing you. You're literally trying to poison the well.
Medications that you lost 2 over 4 kids. Ma'am, these are bad.
She lost 2 of her 4 kids. That means she kept 2. So the state trusts her with 2 of her kids.
Those issues are relevant for my consideration, sir. There is a particular statute that applies here.
They're not.
There's a particular statute that applies here. Here's the particular statute. And he's saying they're very relevant. No, Chillie. No, they're not.
Telling you the truth, and you're not looking at the evidence. I'd like to call my witness, Zane Kane, and start to introduce real evidence and affidavits from people who she also stalked, harassed, and caused major fear and anxiety in.
Her harassing and stalking other people doesn't mean she harassed and stalked you.
I'd like to call my witness with all the evidence I prepared for the past 2 weeks. I'd like to introduce the evidence and not just people talking.
People talking is evidence. Most evidence in a trial is adduced through people talking. At the trial that I'm going into, opposing counsel has an expert witness, a forensic accountant. I have an expert witness, a hepatologist, whatever. He does liver and he does liver ailments. I have something like 7 or 8 witnesses for my client who are going to get up on the stand and testify. None of them have submitted affidavits. Opposing counsel has like 4 or 5 witnesses that he's going to put up on the stand, and they're going to give evidence. And in order to introduce paper evidence, you have to have someone on the stand who's going to testify as to what that paper is, where it came from, etc. So 95%, I would say, of evidence at a trial is testimonial evidence. Most of the rules of evidence deal with testimonial evidence. I mean, that's what courts are. That's why they're witnesses. That's what evidence is.
I'd like to introduce 4 affidavits from other people.
I'm not going to consider the affidavits, sir. Those are hearsay.
They are hearsay. They are out-of-court statements offered for the truth of the matter asserted therein.
Your Honor, you have to look at the videos that she makes. This is insane. You're listening to people who are putting on a good front, but they're the bad people.
Just say what's in those videos. Say, in this video, on this date, she did this that constituted harassment as defined in Massachusetts General Law, Chapter 258E, Section 1. That's what you say. Like, why are you arguing with the judge? How are you going to win? The judge gets to decide who wins. Why are you arguing with the judge? That's dumb.
This is beyond reasonable. I'm trying to explain to you. At least 3 events, I'd like to call my witness so he can testify what he's been through by just knowing.
But see, what he's been through is not what you've been through, Chillie. And you have to prove what you've been through, aimed at a specific person. You have to be the specific person it's aimed at, Chillie.
And I introduce evidence.
What he's been through is not relevant for me to determine if you've experienced something such that you should receive an order.
Right. I'm receiving.
So again, Mr. DeCastro, I need you to address what Ms. Peters and Mr. Abrams have said.
Everything they said is a lie. It's not true at all.
The nope defense.
Nothing they said was truthful, Your Honor. I got the video showing you. You won't, for some reason, you won't accept it. I sent the man there from New Hampshire. He did get his protection order. She violated it immediately.
See, he keeps defaulting back to, oh, this guy in New Hampshire, he got a protection order. That doesn't mean shit for you. That doesn't mean you qualify for a protection order. Lots of people have protection orders. That doesn't mean you qualify for a protection order against her or him.
She violated a harassment protection order last week against a woman named Warren.
That doesn't mean that you get a harassment protection order.
This is what she does for
Are you a party to that order, sir?
Are you a party to that order? Oh, that is a very probative question.
Take as a judge all relevant information that could be pertinent to the case.
Are you a party to that order?
Are you going to let me?
Got to know?
I'm not. Are you going to let me decide who to call my witness?
I'm not.
Asking you if you're a party to the order involving Ms. Peters and someone else.
No, are you going to allow me to interject?
Okay, so again, Mr. DeCastro, I need you to stay on point and speak to me about what I just heard Ms. Peters and Mr. Abrams tell me. They
See, he is going off point. He's very much going off point.
denied every single thing you said. They've told the court that you've been live streaming your location and that they're able to show up because they're live streaming your location. They tell me that they're not stalking you at all. They tell me essentially that you are all YouTube people who have YouTube followers, who neither of you all can control what your YouTube followers do. That's what I have in front of me so far. I need to understand why you believe they are harassing you such that you should get an order of protection.
That's a pretty fair statement of the relevant facts.
Address online.
Put my address online. Okay, she put your address online. How does that satisfy this?
Put my address where I'm at right now online. When I got here, there was dog shit on my door. It's on video.
There was
Did she put the dog shit on your door? Did she cause the dog shit to be placed on your door?
there was what on your door?
Dog poop on my door. It's on video. I got a video of the whole thing. She came to my location in Boston and posted a picture of herself in the lobby of my building. She went to where I was on a summer vacation in New Hampshire and showed up there and put her name up there. Kate trolls always win. They have the pictures right there.
She did it. She did it. She went to New Hampshire. Interesting. She went to Denver. Interesting. Kate travels the country. Interesting.
She showed up at my location to intimidate me and cause fear.
Speaking of which, Kate's in Massachusetts and Chillie is in Denver, Colorado. Would it be reasonable? Would a reasonable person be scared of a woman who is half a country away? There's a lot of states between Massachusetts and Colorado. I'm not sure it would be reasonable to be scared of a woman who is that far away, who had the audacity to take a picture of herself in the lobby of the apartment building that you were staying at for a short period of time.
And then once she marks my location, the trolls will then literally go into physical violence.
Again, the judge has the whole trolls, Kate marking the location. You're not helping yourself. You need to focus. These are the things you need to prove. If you can't prove these things, then you shouldn't have filed in the first place.
She chased me down in Memorial Day. Her video says, I stalked him across the city. I was checking in with the private Discord server. Is he still there? Yes, he is. I'm driving across the county, white knuckles, and we're tracking him. I'm like, is he still there? And then she says, he's not getting away without a confrontation. And then it shows me, push her away from me. Then I went and filed a police report because it...
Again, so she showed up and then you pushed her away from you. You initiated physical contact that could be characterized as battery or assault, depending on how Massachusetts writes its criminal laws. You're not allowed to touch people, Chillie. You're not allowed to touch people. Are you claiming self-defense? Was she standing there menacingly in a Patrick Star from SpongeBob SquarePants reference? He was standing there menacingly. And again, you filing a police report is just you filing a police report. Anybody can file a police report. It doesn't mean anything, Chillie.
Physical. I didn't ask her to track me down to where I was in Boston.
Because it had become physical. Because you just admitted that you physically assaulted her.
Literally on video saying I raced across the 2 different cities to get to him. She parked my car in. There's a photograph.
So she showed up where you were in a public place, where you were live streaming. She showed up to where you were at a public place live streaming, Chillie. What if, so you, by your own admission, you're a national figure, you're a celebrity. She showed up to where a celebrity was doing a live stream. That's not stalking or harassing. Not in and of itself, anyway.
She parked my car in so I couldn't leave. She said it on video. I parked him in so he couldn't go. I was going to have a confrontation with him.
I parked him in so he couldn't go. I don't even know what that means. Were you able to leave, Chillie? Were you able to leave? I'll bet you were.
That is not free speech, Your Honor.
What date was this, Mr. DeCastro?
That was Memorial Day where she came.
Uh-oh, that was Memorial Day. Guess what? Guess what, Chillie? Guess what? That Memorial Day one? That one's res judicata. It's already been decided. A judge has already found that wasn't harassment. What day was it, Chillie? What day was it, Mr. DeCastro? Oh, it's Memorial Day. Oh. That was the one that has already been adjudicated.
Now, where Josh was privately texting her our location, he was my friend. So saying someone chased
And he was privately texting her the location on Memorial Day?
where I was, and then Josh filmed our interaction so that they can embarrass me online.
He filmed your interaction so he could embarrass you online? Is that stalking and harassing? Oh, no, that's free speech. Sorry, bub.
They did it together. But if I chased across the country and it said, I'm chasing across the country and I'm checking in with people to make sure she's still there, my God, I can only imagine. And this is ridiculous. I was raised as a feminist, with 7 women. I identified as feminist.
I was raised as a feminist. I've identified. Who cares? Who cares? Are you trying to counter Kate's belief that you like to target her because she's a woman? That you feel you can intimidate her and bully her because she's a woman? Is that what you're trying to counter? With your Sally Jesse Raphael glasses? I don't know. I don't know if any of that's part of this. I don't know if being a feminist is something that excuses you from bullying women. I've identified as a feminist my whole life. The idea that I'd be jealous of a woman's success is just... Okay, really, dude? Like, I've seen you drooling over her accounts, or her GoFundMe or whatever it is, FundGo, getting all butthurt over all the money that you thought she was making in your name. You're a tool.
My entire life. The idea that I'd be jealous of a woman's success is just a way to try to...
Look, do you see the way he looks away? Did you see the way he looked away? Watch the way he looks away. It's eye contact until the lie. Watch for it.
Women, I've identified as feminist my entire life. The idea that I'd be jealous of a woman's success is
he can't maintain his eye contact. He's Captain Eye Contact until that. Boy, that was a tough lie to spit out, wasn't it there, Chillie? That was a tough lie, wasn't it, buddy? Ooh. You ever watch those behavior panel guys? It was pretty fun. I wonder what they would have to say about this.
how can you like poster on her? That's crazy.
Look, he keeps looking away. He keeps looking away. He keeps looking away.
Just take a look. I like to call Zane.
See, and now he's back to eye contact. Now we're talking about Zane. Now it's back to eye contact.
9-minute video that shows the actual events that happened in order.
See, this is an easier lie for him to do. But that other one, boy, that was a tough one for him. That was hard for him to spit out. Oh, it hurts so bad that a woman is more successful than he is. It hurts so bad.
Tell you really the story, but the evidence shows something completely different. And when you listen to Zane, they have, just knowing me causes me that problem. Because the total harm is past anybody I know. It's way past what you think. I'm suing them. You know how hard doing law is, federal tort law, filing a lawsuit against these people?
Do you know how hard it is to file a law and federal law? Oh my God. Yeah, she knows, dude. She's a judge. And she's not impressed. She's not impressed by how hard it is just to file the lawsuit, you ninny. You ninny. It's easy to file a lawsuit. You're the one who folds after the filing, bro. Like, look at the half-ass effort you put in on this. Completely unprepared. You didn't know what harassment means. You're arguing all these things about things that don't matter. You have to argue that she's harassing you as this definition defines it.
It's an amazing amount of work. I just want them to leave me alone and stop talking about me and let me go on with my life. It's not prior restraint, it's stalking me.
No, actually, you want them to not talk about you. That's prior restraint. Saying if the judge issues an order that they can't talk about you, that is prior restraint. And I don't believe that's an order that the court can issue. I think they can order them not to contact you, but I don't know that one of the remedies that a harassment prevention order can grant is that they can't talk about you. Let's see, I think have the remedies. All right. A person may petition the court for an order the defendant, number 1, refrain from abusing or harassing. 2, refrain from contacting. 3, remain away from their household or workplace. And 4, pay for the monetary compensation for losses suffered as a direct result of the harassment. So those are the that's the relief that the court can order. So, I don't know that the court can give you what you want there, sweaty man.
The video, they broke my doorknob on my front door. There's dogs, there's glue all over my hand. You can see it.
Oh, the dog shit defense. Oh, the dog shit, that's a winning defense. Look at him, he's so proud of himself. There was dog shit on his hand, you could see it. And who put it there? Was it Kate or was it Josh?
You won't look at it, though.
All right, Mr. Castro, thank you.
You won't look at it, though. She doesn't need to look at it. She can assume that what you say is correct. But is it harassment? is it harassment as defined 258E section 1. I keep going back to it because people need to remember it has a specific definition. And it has to be Kate or Josh, directly or indirectly. I mean, they could order someone else to do it, but it has to be them specifically causing the dog shit to be put on there. And it has to be fear, intimidation, abuse, damage to property, 3 or more acts. That would probably be damage to property. 3 or more acts of that. You've alleged 1. If you're even alleging that it was specifically Josh or Kate or both who directed someone to do it, specifically directed someone to do it, then that's 1. You need 3.
For your testimony, I've heard enough to make a decision in these matters. The legal standard has not been satisfied, sir.
The legal standard is preponderance of the evidence in Massachusetts. That means 5149. So he didn't have more. You know, on the balance of scales, it has to be just enough to make the scales tip in his favor. He didn't meet that standard.
For either of your requests. As such, your request for orders against both Mr. Abrams and Ms. Peters is going to be denied. This hearing is now concluded.
Can I call my witness?
This hearing has concluded.
You haven't alleged anything. So if you brought up your witness and your witness talked about the dog poop, that's not going to help. If you brought up your witness and your witness talked about Kate violating a harassment order that they had, that's not going to help. You have to actually allege what your witness could have testified to. Like, hey, you know, they did this to me. And it's going to be to you. It has to be to you. All your witness can do is then testify, yeah, I saw them do this. You see what I'm saying? Like, because these things have to happen to you, because they have to be directed at you, you're the specific person, your witness would have to testify to the things that you know. You would have to know them. So you could say, yeah, these are the things they did. Oh, and I have a witness who could testify to it. That's different. But you're not alleging anything that a witness could testify to that meets the definition of harassment.
Concluded, sir. You're all set. You're all set. You're all free to go. Call the direct court officer. Please. No clapping, no applause. No,
Oh, that's funny. The courtroom breaks out into applause.
no applause. Please follow the direction of the court officers. You all can leave one
Oh, Chillie mad. Chillie big mad.
at a time. Mr. DeCastro, the hearing is over. Whoever's controlling the Zoom, Mr. DeCastro can leave the meeting at this time.
She's trying to get rid of him bad because he's up there talking smack.
What a joke.
Is it a joke? Or are you the joke, Chillie?
To all the other Zoom users, thank you for your respect. You're obviously free to stay. This is a public forum, but you can also leave if you're no longer interested in the day's proceeding.
Yep, Chillie's a big joke. Anyway, there you go. Thanks for watching. Have a great night.